of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw and give their attention, for the court is now sitting. God save the United States and this honorable court.
Welcome, everybody. We'll hear argument in the first case, 21-1415, Holbrook versus TVA. We'll hear from appellant's counsel. You're on mute.
My name is Martin Beanstock, and I represent plaintiff David Holbrook in this action. Mr. Holbrook has alleged that he pays an inflated electricity bill each month because TVA is ignoring a statutory directive about how it is required to set his rates. Still, the district court dismissed his complaint because it concluded federal courts do not have jurisdiction to review TVA decisions relating to rates. The district court's decision needs to be reversed. Courts always have jurisdiction to review agency decisions where, as is the case here, Congress has supplied them with a meaningful standard for a court to apply. The second sentence of Section 11 of the TVA Act specifically directs TVA on how to allocate rates between industry and consumers. The second sentence has two parts: a policy directive, a policy statement, and a directive. The policy statement says that when Congress financed the TVA and when it financed its projects, its primary purpose was for the particular benefit of consumers like my client. The directive in the second part says, accordingly, TVA sales to industry shall be a secondary purpose to be utilized to secure revenue returns and load factors, which in turn will produce the lowest possible rates for domestic consumers. And the second sentence uses the word shall, and it uses it twice. There's no reasonable basis to dispute that this sentence supplies a directive to the TVA. It requires that the TVA, when it sells power to industry, it needs to adjust two factors, load factors and revenue returns, in a way that produces the lowest possible domestic rate for consumers like my client.
Just before you get going too far on that, why don't I read, the description here, the sentence you're referring to, or the clause, I guess you're referring to, that talks about the high load factor and revenue returns, which will permit the lowest possible rate. Why don't we view that as a directive instead of a prediction, right? That they're saying by doing this, it will lead to the lowest possible rates, as opposed to a directive to do so.
Well, the
permit sounds like a prediction more so than a mandate.
I think the mandate lies in the previous clauses, and the verb.
Just make sure. So the will permit is the prediction that if they do this, it will lead to the lowest possible rates.
Correct, and it's the prediction of what it is that the TVA is directed to try to accomplish, right? So it's use these two things in a manner which will permit this outcome. But it's the other term that I think is crucial is the term accordingly, right? So you begin with the policy statement, and then you say accordingly, it shall use sales to industry to be used principally to secure something. So all of that, I think, contributes to the conclusion that this is a directive to TVA onto what it needs to accomplish.
Mr. Beanstalk, could I ask you about the agency action at issue here? Because this is, I think, part of what's driving my sense for that this is odd. So am I right that the actual specific agency action you're challenging here is an amendment to a contract?
No, Your Honor.
Well, what is the agency action that you are challenging?
So the complaint specifies at least 3 instances in which TVA engaged in something it calls a rate change. When it adjusted the rates that it set for industry and consumers with the purpose of reducing rates to industry and increasing it on consumers to implement
am I right that
fairness.
But am I right that when you say they're adjusting rates, they're doing so through their contracts, right? It's not like they're putting out a final rule or an agency adjudication or something like that. It's these rate adjustments happen through the mechanism of the contracts, right?
They happen through the mechanism of the contract, but TVA has the authority to set the retail rates. It's within its power to do it, and it implements it through this process. In fact, the statute. I
guess my question is just before you move on that, are you aware of any APA cases where the agency action that's being subject to judicial review is in a contract with a third party?
I can't say offhand that I do, Your Honor. At the same time, I mean, the effect of what it's doing is to require that the rates be set in this manner for the consumer. And in fact, this is what Congress directed it to do, right? Congress said you can do it through either through regulation or you can do it through contract. But what Congress directed it to do was to utilize the sales to industry in order to generate the revenue returns for the consumer. So Congress has directed it to do that. And the TVA, it is alleged credibly that the TVA is not doing that. So while the form may not be recognizable, it's still violating the directive of Congress as to what it needs to do.
Well, can I follow up on your allegation that you're saying they're not doing that? Because it strikes me that you could be making one of 2 claims. So one claim that I understand you could be making is that TVA is directed to strike the balance in a certain way, and that you think that TVA is just striking the balance wrong. The other thing you could be claiming is that TVA is required to consider a series of things, and it's just ignoring one of them. And when I read your blue brief, I see you making the latter argument. Well, I see you making both of them, but I see you making the argument of TVA is just literally ignoring one of the things that it's been told it should consider. But then I look at your complaint, and I'm not sure that I see that allegation in your complaint. When I read your complaint, I see TVA is just getting the balance wrong type arguments. Could you tell me where in your complaint you think you allege that TVA is literally ignoring a statutorily required consideration?
I can't point to the paragraph in the complaint right now, Your Honor, but I do believe that we reference its policy goal of achieving fairness and equity, which is directly in conflict with the statutory requirement that its goal be to produce lowest possible rates for domestic consumers.
Well, I understand. I'm asking you on the spot. I know you're going to have some time in rebuttal. That would be very helpful for me if you would be able to identify where you think in your complaint you come closest to alleging not that they're weighing 5 factors and they're getting the balance wrong, but that they're literally ignoring factor 3 entirely. It would be very helpful for me to know where in the complaint you say you allege that.
Yes, Your Honor. So we do think that under State Farm, Your Honor, they're required on remand to the district court. The TVA would be required to show both things. TVA is required to attempt to use load factors and revenue returns to achieve lowest possible domestic consumer rates. That's one item that they're required to show under State Farm. And the other is that they need to show a rational outcome, that the rates that were produced are rationally related to the statutory standard. And we believe that they violated both of those things. We've adequately alleged that they violated both of those things. First, like I've said, their policy statements clearly say that they're trying to achieve fairness. And then we've shown that the relative rates that they charge are worse for consumers than even their for-profit peers who have no similar directive. So we think both of those are sufficiently credible to allow the complaint to state a claim here.
What if they said, and I get that they didn't articulate it exactly this way, but if they had said, you know, we need to attract business, right? Because business is necessary to create revenue and to create a sufficiently high load factor. And one of the things that businesses look at is whether they're being treated fairly, right? And, you know, because they do not want to, you know, be in a place where are subject to the demands of an energy provider who's not going to treat them fairly. And once they move, they're sort of stuck there. So they want a business or a power company that treats business and consumers fairly. And that's an important thing for businesses to understand. Why wouldn't that be an entirely permissible manner to meet, even if we called this a mandate? Why wouldn't that be an entirely reasonable way of doing that?
So if
and why fairness is bad from your perspective, you're saying they can't consider fairness. I guess I'm having a little hard time seeing why that's not permitted by the statute.
And Your Honor, I don't think that fairness is bad. I think it's a legitimate policy choice. It's just not the choice that Congress made. Congress said that they need to use the load factors and revenue returns to generate, to secure a lowest possible domestic consumer rates. It's a policy judgment made by Congress. Now, I'm not saying that load factors, that they need not consider load factors, and that load factors wouldn't reasonably drive the rates to industry lower and rates to consumer higher. All of that is something for the TVA to present to the district court judge for a decision, but we're not there yet. The district court dismissed the case for lack of jurisdiction, and that's the issue that we're here on. The district court held that the court lacks jurisdiction to review TVA rates because TVA rate setting is unreviewable, and that's just inconsistent with all of the leading Supreme Court and Fourth Circuit decisions that address the issue. TVA rate setting is not an exception to.
Well, client, excuse me. Can't we view the district court's ruling kind of as two-pronged? So there's the district court did rule that TVA rate setting is not reviewable, and it cites some cases for that proposition. But then the court also ruled that there's no meaningful standards provided in this statute on which you're relying by which to judge, that this statute is, you know, it's setting a policy that speaks in very sort of ambiguous terms about predicting what will happen if we do certain things, and that's not a standard that judges can measure agency action by. And that those are kind of two separate ways that the district court got to its conclusion. So we don't necessarily have to embrace the idea that all rate setting is off the table in order to agree with the district court that the statute on which you're relying doesn't give us a meaningful standard.
Yes, Your Honor. So the meaningful standard, courts require review if there's any meaningful standard to apply. And under State Farm, that review can be did they look to those factors to achieve the outcome that Congress required? And at this stage of the proceeding, that's really what we're asking for. We're asking for.
But I think that goes back to your conversation with Judge Heitens, that's not really, you didn't really plead they didn't look at the right factors case. You pled a case saying that they're not charging the rates they're supposed to be charging. They should be offsetting domestic rates with the rates they're charging to industry, not, here's the 5 factors and, they didn't look at factor 3 and 4.
Well, yeah, so I think that a challenge under the APA should raise both issues, and that the court should be allowed, the district court should be requested to look at both of those issues on remand. I think that the district court, as part of its review, should be required to look at both.
But again, you have to plead it that way. But again, if you could point to something that would be helpful in your pleading to show that this is a case about failure to consider required factors. I didn't find that in your complaint, but that kind of goes back to Judge Heitens' question.
Yes, and I would still say that without having looked at the complaint, but even if the complaint only alleges that the outcome was wrong, I think the court, that's a sufficient basis on which to bring the issue up for APA review, and that on APA review, it's TVA's responsibility to bring forth both, to show both steps that are complied with the process and that it produced a reasonable outcome.
Can I ask a slightly different question? When we talk about rate setting in general, you refer us to the FERC cases, but FERC is not actually setting rates; they're reviewing rates. So, accepting the FERC cases, do you have examples or any example where a court has found rate setting to be reviewable? And I'll posit that postal rates, there might be some difference there. We can talk about it if you want to, but are there any other examples where government rate setting, not review of other rates like FERC, but the rate setting has been reviewed by a court?
So I don't have a case offhand, Your Honor, but I'm pretty certain that Section 504 of the APA includes rate setting as agency action that's subject to review under the APA. So I think it gets swept in with that rubric, that rate setting is subject to review under Section 504.
But you're not aware of any instance in which a government entity that's selling something sets a rate in a contract and it's been reviewed?
My time is up, Your Honor, but no, I'm not aware. Thank you.
All right, Ms. Gillen, we're happy to hear from you.
Good afternoon, Your Honors. Maria Gillen, appearing on behalf of TVA. May it please the court. I'd like to pick up where Judge Heitens went. You're exactly right. The complaint alleges that the resulting rate was incorrect, not that the methodology used to get to that rate was incorrect or failed to consider factors. So that under this court's precedent, Angelics and Electricities is not reviewable. Also, I'd like to point to what Judge Richardson said, which is that it's a prediction, which suggests, as it is, that Section 11 is a policy, not a directive. The plaintiff alleged, as Mr. Bienstock said in his opening, that the rate he pays for electricity is too high. And he asked the district court to order TVA to lower it to some unspecified level, which he didn't indicate. He argues that Section 11 entitles him to that rate, which it does not. In order to do so, he has to rewrite Section 11. It's not a subsidy mandate, as he argued below, nor is it a directive, as he rebrands his argument for this court. It's a congressional policy statement that, when read with the other sections, 10 and 15D of the Act, guide the TVA board in distributing federal power to meet all of the objectives of the Act. But Section 11 doesn't in any way dictate how rates should be structured between various customer classes to meet those policy objectives. Congress left the how to the TVA board. And key to the district court's holding that rates are not reviewable was its rejection of the plaintiff's reading of Section 11. It correctly observed that the statute simply does not say what the plaintiff suggests it does. The district court should be affirmed.
Can I ask you about that?
Yes, Your Honor.
And this is a little bit of a tangent, so I don't want to take up a whole lot of your time with it. But if I agree with you that the statute just doesn't say or require what the plaintiff claims it does, is that a matter of, he's just failed to state a claim because he's saying, the agency failed to do X when the statute doesn't require X? So he's failed to state a claim? Or is that a matter of, as the district court thought, a statute without meaningful standards to be enforced?
I agree with you, Your Honor. The line between 12B1 and 12B6 here is a little fine. We moved under 12B1 and the district court decided it under 12B1, finding that there was no jurisdiction, no manageable standards for TVA rate making for a court to review. However, in accordance with this court's precedents, the district court confirmed that there were no improprieties as alleged, and that was the part of the opinion where he reassured himself of that. So I don't know if that answers your question. I think you had said that before because you said two ways of approaching it.
May I ask you a question about go ahead.
Again, I don't want to take a lot of your time, but I agree with you that it's a kind of a fine line in a case like this where if we disagree with the plaintiff, like the statute just doesn't require what you say it requires, it feels a little more like failure to state a claim, right? You're claiming the agency didn't do something that it's not required to do. So, there's no problem here. But, we do have precedent where we deal with cases that are kind of similar to that in the way of saying, well, there's no jurisdiction because we can't impose that sort of standard on the statute. I think this case raises the question of where that line is.
Yes, but I would look to Angelex, Electricities, and Littell, and they all say that it is reviewable to the extent that any improprieties of the sort that may require review. And so in order to do that, it was necessary to look beyond. I think it could be decided either way, but the standard is the same, I think, under 12B1 or 12B6 at the district court.
So I want to ask you about the breach of contract and exaction claims, because I agree with you that I think, is this a 12B1 issue? Is it a 12B6 issue? That's maybe a hard question. I don't understand how the district court thought it could dismiss the breach of contract and exaction claims under B1, because as I understand, the committed to agency discretion by law, the APA creates a cause of action and then claws it back if it's committed to agency discretion by law. But that's an exception to the cause of action under the APA. But the breach of contract and exaction claims aren't APA claims. So I don't understand how a provision that limits the APA can withdraw jurisdiction over those claims. It seems to me that's failure to state a claim, not lack of subject matter jurisdiction. But I guess I want to give you a chance to convince me that I'm wrong about that.
Well, Your Honor, and I think that goes to Judge Rushing's question because it hinged on the faulty reading of Section 11, because necessary for an exaction is an illegal action. And there's no directive in Section 11, so therefore there was nothing that was illegal about the rate.
Sure, but that's a 12B6 failure to state a claim. That's not a lack of subject matter jurisdiction because it's committed to agency discretion by law, which is an APA doctrine, not a breach of contract doctrine.
Correct. I in the long run, I don't know. Of course, it matters. Rules matter, but in the scope of review, I don't know that it matters, and it is consistent with what this court has done previously in similar cases to look behind the merits. Yeah. Did that answer your question, Judge?
I take it what you're saying is we should affirm on the alternative basis that it should have been dismissed under 12B6 if we agree with the determination that it's not a directive.
Correct. Okay, let me see if there's anything else I need to say. Oh, I did want to go through load factor if it's necessary for the court. As Mr. Beanstalk said, there are two factors. I think he said you have to adjust two factors in a way that results in the lowest possible rates. He's ignored and misunderstood load factor to a great extent throughout the lower court and this court. Load factor is a system-wide issue, which means that it is not separable by customer class, as he has argued. It is the average demand for electric power over a specified period divided by the peak demand during that same period. So what that means is that high load factor is essential to making an efficient system and keeping rates low for all. Key to that is industry. As I think Judge Richardson alluded to, it's imperative to be fair to industry so that they are attracted into the Tennessee Valley region to keep load factor high and rates low for all. And the 1938 annual report segment, which we put in the JA at page 9, kind of explains that concept from the early days of TVA. If the court has no further questions, I'll sum up. So
how about respond to the, I asked the question about rate setting, and certainly there seem to be a number of cases that suggest, at least in the examples that we have, that rate setting is not, is committed to agency discretion. What's the response to the argument that, well, then why does the APA include rate setting expressly as a rule?
So I believe the distinction is that we are a federal entity distributing federal power, so that those rates deal with rates to private parties. I actually was not very successful in finding rate cases discussed under that section of the APA, but it doesn't apply to the TVA Act because.
So I take it that you would then say that that's really referring, or at least could be referring to, like the FERC's review of rates. So FERC reviews all sorts of rates in its orbit, but they're not its own rates. It's the rates of those that it regulates.
Yes, I'm sorry to cut you off, Your Honor. Yes, absolutely.
No.
And FERC operates under a completely different organic statute, the Federal Power Act. So to sum up, plaintiff seeks to override rate-making decisions by the TVA board based on an incorrect reading of part of one section of the Act. His argument that the TVA Act requires rate makings where industrial users subsidize residential users has no basis in text, the structure, or the purposes of the Act. TVA asks this court to affirm the district court. Thank you, Your Honors.
All right, Mr. Bell, we're happy to hear from you.
Yes, sir. May it please the court. I'm Cameron Bell. I represent BVU Authority. We are the local utility who Mr. Holbrook is the customer of. I don't really have a whole lot to add. I'd be happy to add some gloss from the local perspective on both the practicality of some of the things that you have raised and some of the legal issues that have been raised about 12B1 and 12B6. But at the start, the reason that we were here, Mr. Beanstalk is correct. What happened was the court ruled in the district court that there was no jurisdiction. All of the cases that have been decided involving TVA on these types of questions have ruled that there is no law to apply, and therefore there is no subject matter jurisdiction over the case. BVU is in a little bit different geography. And I think that's the only reason that we're here, and we're here in the district court in the first place. We're slightly over the Tennessee line and within the Fourth Circuit, as opposed to all the other cases in the primary TVA area in the Sixth Circuit. But all those cases have decided based on these factors that Section 11 and Section 15 have platitudes and what generally should happen, but not something specific enough to allow a court to say, this is what the rate should be. And you'll note in the complaint, and in addition, this is, the plaintiff has amended the complaint. The complaint that was dismissed was the second try to state a claim. But what he asked for in the ad damnum is for the court to award damages. So the district court is supposed to analyze under this platitude framework what the damages to Mr. Holbrook and others of what their rate differences would be. And that's just not what the statute says. That's not what the APA is for. All the cases that have been decided along those lines have held that. So I do think it is a 12B1 question and not a 12B6 question on that basis, but also on practicality, Judge Richardson. So being the outlier of the TVA area, somebody in Bristol, which you may know is on the line between Virginia and Tennessee, they could literally move across the street and have a different power supplier. So Bristol Widgets Company is getting charged too much by TVA. They can go somewhere else as easily as moving around the block. And certainly in Washington County, which is also in BVU's service authority, they can go to Appalachian Power and many others easily. So the calculus, and again, this isn't something that I think Congress intended for courts to engage in, but showing the complicated nature of it all is, if we charge Bristol Widgets too much, so Mr. Holbrook pays a little bit less, then they move and everybody pays more. So that's in the calculus of what TVA actually did. I don't think that's what the court should review, but that's the practicality behind all those things. And it's also worth noting that the plaintiff attached 400 pages of things that TVA actually considered. Many of those issues are what the plaintiff is raising now that supposedly were not raised in his brief. Similarly, the plaintiff argues in his brief that the Sixth Circuit and other district courts in the Sixth Circuit gave short shrift to the 12B1 argument. They just sort of cut and pasted earlier decisions that TVA rates were non-reviewable, when in fact, if you look at the Matthews case, for instance, there's a footnote in that case where they read law review articles raising many of the same issues that had been raised in this case. That all said, as to BVU, all we did was supply power to Mr. Holbrook. We're not allowed to make rate determinations. TVA makes those rate determinations, so there aren't any claims that have been stated specifically against BVU in any event. But what Judge Jones decided, I believe, is because the fundamental question under any of the counts is rate making, because under the APA that isn't reviewable because there isn't a law to apply, then all the other cases, claims, whatever you call them, fall the same thing. Now, the hierarchy is, of course, the court has to analyze jurisdiction first, because there is no jurisdiction to read into what TVA sets its rates at or not. Then all the claims have to fall based on that jurisdictional argument. So that's why he didn't state a claim against BVU, and that's why we would ask that the court affirm the district court's judgment. I'm happy to answer any questions that your honors have.
Seeing nothing from my colleagues, we appreciate it, Mr. Bell. We'll hear from the appellant again.
Thank you, Your Honor. I did have a chance to review the complaint, and we do allege in a number of places that TVA did not set rates in accordance with the requirements of the second sentence of Section 11. Not just that its outcomes were wrong, but that its process was wrong and that it failed to consider the appropriate factors. We define on page 5 the relevant clause in Section 11 We call it the lowest possible domestic rates provision. And then in paragraph 117, we allege that TVA, when it adopted its strategic pricing plan, it neglected to consider in any way the lowest possible domestic rate provision. Paragraphs 110 and 113 address it in the context of fairness. We say TVA has adopted a policy of fairness, but the process required by second sentence of section 11 is not fairness, it's lowest possible domestic rate. And in both cases, we say its goals, and it's in goals in paragraph 10, and its description of its purposes in paragraph 110 are not consistent with the lowest possible domestic rate provision, which is the process that's required of it. And you know, the words are italicized, the words required to consider load factors and revenue returns. And that is a reference to the provision in that section where it was supposed to consider those things, but it didn't. In our cause of action, we have two separate paragraphs, paragraphs 144 and 145. And the first could be read to talk about the level of the rates. But paragraph 145, I think it's that one, I think the first one says it doesn't set rates, it sets rates that were not in compliance with that section. I think that would encompass both styles of review. But paragraph 145 says it failed to meet its obligations to set rates in compliance with the lowest possible domestic rate provision. And that's a reference to its process, its failure to consider load factors and revenue returns that would produce the lowest possible domestic rates. It's clear on its own, but it's especially clear because elsewhere throughout the complaint, we complain about TVA's purported approach of using fairness when fairness is not what's required under the Act. And I acknowledge that it's a policy goal that many of us here might favor, but it's not what Congress directed. Congress directed load factors and revenue returns be used to produce lowest possible domestic rates. TVA is not complying with the statute that Congress established it under. It's violating the law. We have the right to have the district court hear that claim. Thank you, Your Honor.
Thank you, counsel. As you probably know, we would normally come down and shake your hands and thank you in person for your assistance. We can't do that, obviously, but we do appreciate the assistance you've given us and look forward to shaking your hands and doing it in person before too long.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. We'll hear the next. Versus Garland. We'll hear from the petitioner.
Good afternoon, Your Honors. May it please the court, my name is Jennifer Varghese and I represent the petitioner, Mr. Evans Jolmas. Your Honors, the primary question in this case is whether the 1227 A1H immigration waiver requires a living qualifying relative, and specifically for this petitioner, whether Mr. Jolmas's U.S. citizen father had to be alive at the time of waiver adjudication. This court should hold that Mr. Jolmas's father did not have to be alive, and that the BIA erred in inserting the additional requirement of this living qualifying relative. Your Honors, by way of brief history, in 2004, Mr. Jolmas's father started the process for him to immigrate to the United States under the category of unmarried son. He ultimately immigrated under the unmarried son category in 2010. In 2005, however, Mr. Jolmas had married. He was therefore ineligible to immigrate under the unmarried son category. For this lone misrepresentation, Mr. Jolmas was placed in removal proceedings in August 2016. His form of relief, his only form of relief, was the 1227 A1H waiver, which in relevant part is available to a spouse, parent, son, or daughter of a U.S. citizen or lawful permanent resident. Here, I'd like to mention that practically speaking, The 1227A1H waiver is one of the more straightforward waivers to obtain in immigration court. Once the qualifying relative is identified, the immigration judge then weighs the equities in a particular alien's case. So, for example, factors such as the alien's.
I'm sorry, not to cut off your background completely, but to focus this just a little bit on the where I'm having a little bit of concern.
Yes, Your Honor.
I understand the is and son part of this, and that seems pretty straightforward. The question that I've got is whether the father remains a citizen after his death. And we might think about that in a number of different ways, but there are other provisions of the immigration code that refer to citizenship and include while they're alive or after they're deceased, right? That's 1443A and 1551B as two examples.
Yeah, sure.
And so can you talk to me for a little bit about why we think citizenship is something that continues after death in the context that we have, and particularly, and I'll just add this because it's part of my concern, when we look at, the 14th Amendment, it defines a citizen as a person, right? And then it goes on in the second clause of the 14th Amendment to refer to the allocation of representation to the number of persons in a state. And presumably that doesn't mean dead people. We don't count graves when we allocate people. So I'm just having a little bit of a hard time on whether citizenship extends past death or whether citizenship ends at death. And so while he may be the son of his father, if we will, is no longer a citizen because he's not alive. Help me work through that.
Yes, thank you for that question, Judge Richardson. And I think to answer that, we can consider other provisions of the INA. So for example, and this is something I was going to jump into a bit down the road in my prepared remarks, but I think now's a good time to bring this up. I had mentioned in my brief that the extreme hardship requirement that is in some waivers, but not in this particular waiver, meant that there was a stronger argument that the qualifying relative had to be alive in certain waivers, but not necessarily this one. And here I'm speaking about the 1182I misrepresentation or fraud waiver and the 1182H waiver having to do with criminal convictions. I will mention that USCIS, the adjudicating arm or the adjudicating agency, has actually held that because of a provision called 204L, which contemplates how to deal with surviving beneficiaries, that in fact, whereas I had argued that you need to have a qualifying living relative for those waivers, as far as the agency is concerned, and this is in 204L, also in 8 U.S. Code section 1154L, more for purposes of this court today, the provision allows there to be benefits that continue post-death. And so there's an acknowledgement that the qualifying...
but help me understand that, right? So that L provision lists a set of circumstances where the petition may adjudicate it, quote, notwithstanding the death of the qualified relative, right? But the problem is the exception you're seeking isn't included in the list of things, I don't believe. So you don't get, it's almost the opposite, right? So that suggests that for those instances, it extends beyond death. But you might argue, I'm not agreeing with it, I'm saying you might argue the negative implication means that means it doesn't extend for you.
And Your Honor, I think there would be credence to that argument, but there is in the USCIS policy manual a clause that reads, and I'm quoting directly from the policy manual, excuse me. If the qualifying relative who died is the same qualifying relative to whom extreme hardship must be established. So in other words, the US citizen or lawful permanent resident, USCIS treats the qualifying relative's death as the functional equivalent of a finding of extreme hardship. So here we're talking specifically about two waivers where even if the qualifying relative, the citizen or LPR, has passed, the beneficiary can still pursue the waiver, and the death is actually treated as de facto extreme hardship. So there is this understanding that the parent, in this case son, relationship doesn't just continue, but it's recognized that that parent is viewed, or the qualifying relative is viewed, as a US citizen or lawful permanent resident.
But so the problem I've got there is that you don't fall under that. You call it 204L. I thought it was 1151L, but whatever it is, the provision we're talking about, you don't fall within that provision. I mean, you agree that your, waiver provision is not doesn't fall under L, right?
I would agree to a certain extent, because USCIS, again, going back to this policy manual, is talking, as Your Honor mentioned, about certain petitions. And Your Honor listed a few of those earlier.
Petitions to which
yes, but the policy manual goes on to say that the protection that 204L extends also extends to the waivers that may be required when the beneficiary is pursuing the benefit of the petition that's been filed. So right. There is an extension.
You're saying that they claim that L applies to things that L itself says it doesn't apply to?
L doesn't specifically say it does not apply to waivers, but USCIS extends L to the waivers by virtue of the policy manual.
Can I ask you about?
Yes, Judge.
I know Judge Richardson said he understands the son is, continues to be the son, and the Ninth Circuit has said that, and that's true in a very meaningful sense. But I wondered about talking about other provisions of the code. In 1154, there's a provision that talks about someone who is the parent of a citizen or was a parent of a citizen who died in the past 2 years. And again, that's not dispositive, but it made me start to wonder if we can necessarily, if we should question the assumption that the present tense usage in our statute necessarily transcends death, because Congress has referred to someone who was a parent of someone who died, was a parent of a citizen, but the implication being, in some sense, they are no longer the parent of a citizen. Now, maybe this goes back to Judge Richardson's question because the person's no longer a citizen in death, but I wondered if that was usage suggests that maybe we shouldn't be assuming too much about is here.
Thank you for the question. And actually, Judge Rushing, I would answer that in part based on my answer to Judge Richardson's question, which is, again, if the adjudicating agency has said that we are acknowledging that qualifying relative may have died, and not only are we extending benefits, but if specific waivers are also needed by the foreign national to obtain the benefit, we are going to find automatically that there was extreme hardship. There was de facto extreme hardship. So then bringing that back to Your Honor's question, I think that also gives support to, in this case, because the focus here is on whether the parent-son relationship for purposes of this waiver goes beyond the death of the citizen father here, that the word is there doesn't necessarily have to also be amended, or the clause doesn't have to be amended necessarily here to have the clause refer to a parent that has passed and to include a parent that has passed. The parent that has passed is contemplated overall in the phrasing of the waiver, again, being eligible to an alien who is the spouse, parent, son, or daughter of a U.S. citizen.
But can I explore for a minute what is before us and what we can and cannot even decide in this case? Do you agree with me that in both this case and in the precedential opinion they relied on, the BIA didn't discuss and certainly didn't decide the case based on the idea that the dead parent is no longer a citizen? As I read both of those decisions, their interpretation is entirely based on the meaning of is the child of. Is that your reading of those cases?
That is, and Your Honor, I think if we again look at the language at issue here, waiver, of course, being available to an alien who is the spouse, parent, son, or daughter, and then of the citizen or LPR. So to that extent, I don't have an issue, so to speak, with the emphasis by the board. It's just the analysis based on ignoring the plain language and looking at the evolutionary history and the case law was done incorrectly by the board. That's our position.
Well, I guess what I'm saying is maybe you're right, maybe you're wrong about whether after the parent is dead, the parent is still a U.S. citizen. And I think, I don't know what I think the answer to that is. But what's pretty clear to me is that that's not the ground in which the agency decided this case. So I'm not sure under Chenery how we could affirm the agency's decision on a ground the agency didn't rely on. Do you agree with that?
Your Honor, I think since this case was based on the precedential of matter of Federico, and matter of Federico, without qualification, came forth and said that there must be a living qualifying relative. This court can focus on that here in the context of the alien being the son of the US citizen parent. So for our desired outcome, which is we would like this court to hold that Mr. Jelmas's father did not have to be alive for waiver adjudication purposes, I think the court can focus on the exact holding of matter Federico and analyze this per Chevron and find that just based on Chevron step 1, the language is clear and unambiguous on its face.
Can I follow up on that? Because
Yes.
I read Federico, it doesn't identify what ambiguity. We often think about, agencies identifying an ambiguity and then providing a reasonable construction of it. Federico doesn't identify what part of this provision is ambiguous, right? It just says that it's interpreting this provision, and then it immediately goes to sort of policy, right? And it talks about the policy, which is a reasonable way to choose among outcomes if there's ambiguity, but it sort of assumes the ambiguity question, doesn't it, right? And so in that sense, right, we can't narrow it and say, oh, they only talk about this ambiguity as opposed to that ambiguity. They just said the entire thing is ambiguous and therefore immediately to policy, right?
Yes, Your Honor. Frankly, I find it quite shocking that the actual language of the statute is wholly ignored. And I actually find faulty the board's assessment of the evolutionary history of the waiver. Specifically here, I see I don't have much time left, but specifically the issue I have there is that if anything, the congressional evolution of the waiver shows that when it moved from, for example, from being eligible or available to a child to a son or daughter, when it changed from being a mandatory waiver to a discretionary one, where only the AG can decide whether the policy underlying it can be granted. All of these are substantive amendments, if you will, that evidence Congress did contemplate and did make this waiver eligible to an alien whose parent has died. And I do see here my time is up.
We'll be happy to hear from you again in just a minute.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honor. Spencer Shugart for the Attorney General. May it please the court. Based on what I've heard from everyone in that opening segment, I'm going to presume that I'm going to be disagreeing with everyone, which is okay. Now, I think this case is about ambiguity or the perception of ambiguity. Petitioner lied on a visa application, placed into removal proceedings because of it, sought a fraud waiver on the basis of his United States citizen father who was dead. The agency denied his waiver because it said he needed a living qualifying relative. It did that on the basis of its own published opinion, interpreting a federal statute, which means we're talking about Chevron deference, which means all that is needed to affirm the board.
Can you start what I took Judge Hyten's question to be? Does it matter that the agency didn't identify which part of the statute was ambiguous? And does that in some way limit what we can review in that regard?
I have two answers to that. The first is that I think the agency did sufficiently identify where the ambiguity is here, because it did not simply say that it was unambiguous. I think it can be implied fairly from what the board did in matter of Federico, that it was saying we can't tell just from the word is what the nature of the parental relationship is supposed to do in the statute, or what Congress intended towards it. It's a silence. And
right, but why would we assume Federico based it on the word is instead of the word citizen? I mean, I don't know that either of them are ambiguous, right? But based on Federico itself, it doesn't tell us whether they found ambiguity in the word is or they found ambiguity in the word citizen.
I think that you can read that into their take on the Supreme Court's take on the statutory history, because that focuses on family unity, which is about what happens when families are separated, not so much when people die.
Well, that's the explanation for why they're choosing their rationale, right? They're within their like zone of construction, if we want to call it that, or within what they can choose among. They're picking this one for those reasons. But that doesn't identify the ambiguity, does it?
Not to the extent you're talking about citizenship ending at death, but I'm not aware of any precedent that would say that people aren't citizens when they're not dead. I don't think we have a bunch of aliens buried in our cemeteries, not to be glib, but whatever the board's intention was towards that provision. I'm sorry,
Counsel,
go ahead.
I'm interested in this question of why for Chevron deference, why for the two steps of Chevron, does it matter what ground, where the agency found ambiguity, or if it clearly stated where it found it? Isn't step one that we have to analyze the statute ourselves?
Yes, Your Honor, that was going to be the second part of my answer, because whether or not the agency did this at step one or step two, you do step one yourselves and you do it de novo. You decide if it's ambiguous or not, and you don't defer to what the agency found or didn't find in that sense. So all we really need to look at here is whether the agency's interpretation of the statute was reasonable, or if it's unambiguous. That's basically
Counsel,
the end.
Can I ask you a hypo? I'm wondering if under the government's argument, the citizenship is, well, not I don't mean the citizenship in the word citizen. I mean in the sense of the fact this case involves an alien. So let me give you this hypothetical. So I was born in the United States to two people who were both themselves United States citizens. After my parents pass away, and to be clear, they're both still alive, but is the government's view that after my mother and father die, I will no longer be the child of United States citizens? Because that seems to me the implication of the argument you're making.
That is not the argument that I've made. I have not made any argument about citizenship not surviving after death. Apologies for that.
What he means is that's the argument that I'm making.
So you will concede that after my mother and father die, any normal usage of the English language would still describe me as the child of the United States citizens.
The agency hasn't spoken on that issue here, and I'm not comfortable speaking for it in the first instance. The argument that Your Honors are raising respectfully is not an exhausted issue before us. What we're talking about is whether or not a person needs to be alive to be the parent of someone who is qualifying for the fraud waiver. I'm happy to brief this issue about citizenship if Your Honors are looking for a supplemental briefing, but I'm not comfortable speaking to that in the first instance because I don't know what the client's position on it is, frankly. This isn't something I was prepared to argue.
You're on mute, Toby.
Apologies. Thank you, Judge Richardson.
All right, Judge.
Imagine that a woman's will leaves everything to, quote, to my son. That a will says, I leave everything to my son. Assuming that woman had only one male child, is there any doubt in the world to whom that is referring?
No, I would say no.
So doesn't that mean that even after she is dead, he is still her son?
Not necessarily. Let's get into this. I have a whole piece on this, and this is going to be great.
Great.
So ambiguity. Now, what we have to when we're talking about Chevron step one, we're talking about clarity of meaning, right? We're talking about, did Congress unambiguously communicate a meaning when it wrote whatever it wrote? And the first principle of communication is a consensus on the meaning of terms. Now, in this case, we have one phrase, whether a person, quote, is the son of a United States citizen. Petitioners arguing that that phrase necessarily includes dead relatives because of the nature of the parent-child relationship demands that outcome. So what she's asking Your Honors to circumscribe there is the extent and durability of the parent-child relationship in the event that a parent dies. That is not an appropriate topic for a court of law. It's a philosophy topic. It's not something that you can elucidate through a fact. It requires what you just did in the opening argument with.
Well, I don't want to interrupt your great piece about this, but we are a court of law, and I did try to look for other places in the law, specifically in Title VIII, where Congress refers to a parent or child relationship in the past tense, and not in the sense of emancipation or something like that, but death. And one that I referenced previously is in 1154. They refer to someone who is the parent of a citizen or was a parent of a citizen who died. Now, that's going the other way. It's not saying you're no longer the son. It's saying you're no longer the parent. Now, we know that's not necessarily true because you'll always have this bond. It's not like a spouse you can divorce, but Congress sometimes uses language like that to suggest you were related to someone who has died. And that makes me question how much we can read into, the is idea that, in some meaningful sense, these bonds transcend death, but is that really what Congress meant here? What are your thoughts on that?
My thoughts are that it's impossible to tell because it's silent here. It's not something I don't think Congress intended to explore, like engage in a dialectical exploration of the essential nature of being a son, which is what the answer to the petitioner's question requires. I guess
my point is just the fact that Congress has said is the son or is the daughter, and the fact that we know someone doesn't stop being related after death doesn't necessarily mean that these benefits continue, right? That in other places, Congress refers to that relationship with a was, right, in the past tense, because we're speaking kind of colloquially. Yes, in some important sense, you're always the son of your father, but in other senses, he was your father before he passed. It makes me question how much we can read into this particular usage.
I agree. What petitioner is asking us to read into the statute is too much, because the anecdote that the Ninth Circuit relied on in Federico v. Holder to basically innovate the rule of law that says a person is always his mother's son is just that. It's an anecdote. It's not a rule of law. It's a truism. It's a belief. It's not a fact. It's not something that can be proven or disproven. It's unfalsifiable.
Well, can I go back before we get off into the philosophy again? On the vision that Judge Rushing is referring to, I'm not sure what the number is, but whatever it is, the one that says is or was, why isn't that specification in that statute necessary? Because that statute required the parent to make the application. And so whether the parent remains a parent or whether the parent remains a citizen, it doesn't matter. If the parent has to make the application, the one thing we do know is the dead person can't show up with the piece of paper. And so you had to have the past tense there. And the context tells us we needed past tense in that provision because they had to understand the scenario in which the grandparent could make the application instead of just the parent making the application. And so whatever implication that we might otherwise draw from the use of the past tense there ought not to carry much weight, given that it was needed in that context, given that the parent is the one that had to actually make the application. Is that not a fair way to say, even if they use the past tense there, perhaps that's not a meaningful difference?
It is fair to say that. It's not, Congress has kind of been all over the place vis-a-vis the exact question in this case, which is, does a parent-child relationship survive death? They use is and was all over the place because is and was are some of the most common languages.
That's actually, I would say that's not right at all, right? That in every instance, we have no instance in which Congress had said that you are not a parent after death or you are not a citizen after death, right? We have one example, and I think there's one other 1151B, but there may be two examples in which they seem to indicate affirmatively, they need to specify that you remain a parent for this provision after death, but they need that specification for a particular reason, right? Not sort of generically, but because they were required to make application. Right? So they hadn't been all over the place. In fact, they seem to have included parent in every instance. Do you have any instance in which Congress specified that parent stopped at death?
No.
You would.
I don't think that, because they do specify when they need to say it. I don't think that's something that Congress ever intended to explore, no matter what it said. It does define parent at 1101B, and the parental relationship can terminate on the basis of relinquishment or abandonment or lack of a bona fide relationship between the parent and child, or whatever that means. So I don't think Congress was necessarily contemplating that this, like from the baseline, that this was an eternal relationship. I think that if they had meant to say that, they would have.
What about 1430D, where it talks about the surviving child of a parent who dies in military service, right? And it says that extends, right?
Okay.
So that's an example where they are extending it. No? Sure,
and they did so explicitly, probably for a reason. I don't know the statutory history behind that statute. That wasn't briefed. But that's going to get us, I think all of what we're discussing here is proving the point that this is an ambiguous set of language, because Congress goes back and forth. It specifies it when it needs to, and it doesn't when it doesn't. And the big thing.
Just again, I know we've talked. What word in this statute do you claim is ambiguous? I mean, you say the statute. I mean, because the way I hear you saying it is, well, the statute doesn't specify whether X or Y, and that means it's ambiguous. Another way to describe it, which is, I think, a fair interpretation of the Ninth Circuit's decision, is what the government argues is an ambiguity is just attempting to read a requirement that isn't in the text of the statute. So what language in this statute do you claim is ambiguous?
The question is framed by the petitioner, which is the phrase, is the son. And I don't think it's adding a requirement of being alive when those three words, I don't think can be fairly said to say a person has to be alive or dead for the non-citizen to get the benefit, because as you see, Congress is kind of all over the place on here. Sometimes they say it survives, sometimes they don't say anything. And I think this is just simply silent on the question, because again, as framed by the petitioner, what we're talking about is just the nature, like a metaphysical nature of a relationship. And I don't think Congress, just by using those three very common words, intended to comment on what it means to have a parent die and whether that bond continues. And I think that's the ambiguity of it. So if we can move on to step two, the big elephant in the room here is that we know what the purpose of this statute is. The Ninth Circuit and petitioner also did a lot of rhetorical hand waving to kind of avoid having to look at the purpose, but we know what the purpose is. It's been settled for half a century. This is an act of grace, an act of forgiveness towards fraudsters who, by deporting them, would break up family units comprised in part of United States citizens. Then all we're doing at step two is deciding whether or not this is a reasonable interpretation, and reasonableness just requires that it not be arbitrary and capricious or manifestly contrary to the statute. It's not arbitrary and capricious. You can see in Matter of Federico, they were very clear what they were relying on. And it's not manifestly contrary to the statute because the language is ambiguous, and because the result that they reached is consonant with Congress's intent, which is established and which petitioner does not dispute is the actual purpose of the statute. The points of comparisons that were briefed in this case are inconclusive. They're not enough to overcome what we know to be Congress's intent here. Petitioner talks about the definition of a child. The statute doesn't say child, it says son or daughter, but it used to say child, it's fine. But again, parent is defined, spouse is defined, and spouse is defined without reference to a continuing marriage, but nobody seriously argues that marriage is eternal. So what did Congress intend by juxtaposing the marital relationship with the parental relationship? We don't know. It doesn't say. It's not clear. It's not enough to overcome what we know about the intent. Petitioner makes the analogy to the 212I waiver, the version of the fraud waiver that applies for aliens who weren't admitted when their fraud was discovered, because there is a hardship requirement in there. And the argument is that Congress put a hardship waiver here and not over here, and Congress does that deliberately when it does it. And the respondent will concede that Congress deliberately omitted a hardship requirement, but the board didn't impose a hardship requirement. It imposed a being alive requirement, and those are not the same thing. That's a big leap between one and the other. And it's a low bar. You have to be alive to do anything, including suffer hardship, enjoy the fruits of unity with your non-citizen child. I don't think that illuminates anything. It's the same.
Can I ask you about what's actually at stake here? So this isn't a question, am I right? The disagreement between you and your friend on the other side is not about whether this gentleman gets a waiver. The question is whether this gentleman is able to argue that under the facts and circumstances of the case, he should get a waiver. And maybe he shouldn't. Maybe the board would decide that he shouldn't, right? My understanding of this is if we were to grant the petition vacate and remand, even under the conclusion that he was even eligible, if we went that far, the BIA or the Attorney General, I guess I don't know who would make this determination, could say, under all the facts and circumstances of this case, including possibly the fact that his qualifying U.S. citizen parent is dead, we don't think he should get a waiver. They could do that, right? That even this is a question about whether he's even eligible to have the argument heard. It's not a question about whether he's actually going to get relief. Am I right about that?
You're right. This is about statutory eligibility. We have never, the board has never addressed the petitioner's relief as a matter of discretion. But I don't think that should give anyone comfort in just choosing, not that you would choose like a loose interpretation of the statute, but we should still be quite clear about what Congress intended, because Congress added in the discretionary piece before and it could take it away, and we don't want to be left with a looser interpretation of the statute than what was originally intended, just because we were hoping that discretion might catch up any mistakes that we missed in the first place. Well, allow me to just sum this up a little bit. The language is ambiguous. I know that we're not all on the same page in terms of what this means or doesn't mean, and nobody was super impressed with my philosophical discussion. But the point is that the Congress made different comments all over the INA. Sometimes they impose the requirement, sometimes they don't. It's impossible to tell what they intended with regard to the nature of the parent-child relationship. But we know where it comes out because we know what Congress meant when it created the fraud waiver. And as soon as we see that, we can see that the board's interpretation is reasonable. There's nothing wrong with how it came out. Keep in mind that reasonable doesn't mean definitively correct or perfect, or even something that you yourselves would have done in their place. It just has to be not arbitrary and not inconsistent with the language, and it isn't. So, and then you can also say that the board's interpretation ends up with a result that makes sense here. The petitioner doesn't have a qualifying living United States citizen relative, so to grant him the waiver leaves us, the community of American citizens and lawful permanent residents, just with a guy who lied on his visa application. And that doesn't serve anybody's interest. So for that reason, and the reason specified in the brief, we respectfully ask that you deny the petition for review. Thank you.
Counsel?
Briefly, Your Honor, the question was asked in many different ways by this panel. What language exactly in the relevant portion of the statute is ambiguous? And counsel for the respondent couldn't actually identify any language that is ambiguous. So if we focus on the relevant portion,
all right, can I ask you
the son.
Can I ask you a question about that? So our court has said that Chevron is a standard of review that is non-waivable. And you may or may not agree with that. I may or may not agree with that. But that our case law is it's a standard of review. And under Chevron, the court is required at step one to determine whether there is ambiguity. And so does it matter whether the government sort of fails to identify the right ambiguity or fails to identify an ambiguity if there is one there?
I think it's the burden of the government to identify the ambiguity.
But that's not what, I mean, that's sort of inconsistent with calling Chevron a standard of review, right? The point of it is that if it's a standard of review, the government cannot waive Chevron, just like they cannot waive abuse of discretion or some other standard of review. And so we're required at step one to determine whether there's ambiguity. I mean, I'm not sure about this. That's why I'm asking. This isn't like a lecture. This is I'm not sure what to do, because I take your colleague to basically say, there's some ambiguity, but I'm not exactly identifying what it is. But I sort of wonder whether that matters.
Your Honor is correct in that it's the job of this court to see, based on the plain reading, the clear meaning of the words in the statute, whether there is a portion that is silent or ambiguous. But I do think it's telling that government counsel and government's position as a whole is that there's not something that's actually identified for purposes of ambiguity. And if anything, I think there are some attempts here, quite a few actually, to introduce ambiguity into a statute that is clear on its face. This petitioner is the son of his US citizen father. And so as an example, again, to introduce ambiguity, I go to counsel's point about focusing on the purpose of the statute. For Your Honor, this ignores what Congress specifically did in 1981 when Congress changed the 1227A1H waiver from a mandatory to a discretionary waiver. So now it's not this court's job to consider the purpose, and going back to the Errico case, whether a purpose of family unity is supported by the insertion of a living qualifying relative. And this goes to the question Judge Heitens had asked earlier as well. All this petitioner is asking for is the opportunity to pursue the waiver. If the petition for review is granted and he finds himself before immigration court once more, it is solely the job of the immigration judge to assess, hey, is the purpose or one of the purposes of this waiver satisfied when you, for example, as in this case, have a qualifying relative who happened to have passed away. And I'm not arguing that he's automatically going to be granted relief. The absence of a living qualifying relative may be a factor against the favorable exercise of discretion. All this petitioner is requesting is this court to find that he is the son of a US citizen father, even though that parent passed away, and he should be able to put on a case where all of the discretionary factors are considered. And briefly, just going to, again, some of the cases that are mentioned in matter of Federico. I think the Ninth Circuit in Federico v. Holder, when the Ninth Circuit overturned matter of Federico in 2010, did a good job systematically going through the cases. Myung from 1972, Kalazik from 1981, and even going into Verk and Trong, these post-Chevron cases from 2002 and 2018, respectively, and said, this is why we decided these cases the way we did at that time. Especially in the pre-Chevron cases, the Court of Appeals did focus on purpose. This court does not focus on purpose, need not focus on purpose, and the statute is clear on its face. Thank you, Your Honors.
Thank you, counsel. As you probably know, we would come down and greet you. We can't do that under these circumstances, but very much appreciate both of your arguments and your willingness to appear and try to help us out here. We'll hope to see you in person before too long.
Thank you, Your Honors.
Unless either of my colleague needs a break, we'll go to the third.
Thank you, Your Honor. May it please the court. I'm Rick Krautharmel. I represent Keith Barnett. This is a criminal case out of the Western District of North Carolina. It's a drug case. The lone issue in the case is whether the district court properly enhanced Mr. Barnett's total offense level for maintaining a premises for the purpose of distributing or manufacturing controlled substances. The facts of the case are relatively straightforward. The police learned that drugs were being distributed or sold out of and around a residence on Calvary Drive in Gastonia, North Carolina, which is near Charlotte. They recruited a confidential informant familiar with the residence. He knew the gentleman who lived there, who was a gentleman named Rodney Rhodes. He had also met another gentleman in the driveway of the residence, and that was Mr. Barnett, my client. Mr. Barnett gave him his card one day and said, call him if he needed drugs. And so the police had this confidential informant set up a drug deal with Mr. Barnett at the residence. The confidential informant went there and conducted the deal. He testified at trial. It's unclear where exactly the transaction took place. The confidential informant doesn't say they were inside the house or outside the house. He doesn't say he saw Mr. Barnett come out of the house. Mr. Barnett testified later in the trial and said, yeah, that's me in those photos, but that I'm just sitting there at the picnic table. I don't actually give the guy any drugs. So from that, you can infer that it was probably at a picnic table outside the house somewhere. Anyway, based on the controlled purchase, which was audio and videotaped, the police got a search warrant for the house, and they executed that warrant on October 9th, 2017. They drove up to the house in a raid style fashion, and Mr. Barnett was standing out front of the house. He immediately ran inside the house, and then a few seconds later, he ran out a side door of the house and attempted to hop over a They arrested him, and he ultimately decided to go to trial. Two other witnesses testified at the trial and said that they lived in the neighborhood or were familiar with the neighborhood. One of them said that he bought drugs from Mr. Rhodes. They both said that they had never bought drugs from Mr. Barnett, but they would see him outside the house engaging in transactions. Both of them said that Mr. Barnett did not live there, but he would always be there. One of them said that on one occasion he drove up to the house, stayed in his car. He gave Mr. Barnett some drugs. Mr. Barnett took the drugs inside the house and then came back outside the house with the money and gave the gentleman the money, and the gentleman drove away. And so that was.
Can I ask a couple of quick questions to make sure I understand it, because it's a lot of record, and y'all know it a lot better than we do. There were, in addition to the drugs over the fence, there were drugs found in the house.
Correct.
Right. And for sentencing purposes, your client, those drugs were attributed to your client as part of the conspiracy.
Correct.
Just at sentencing, right? So
right.
And just so I understand, that's because maybe it's not expressly set out, but it's because they were, foreseeable to him and within the scope of the conspiracy, right? The same language we hear all the time.
Correct.
Right. So the question I've got is, why doesn't that same standard, we can call it Pinkerton, we can call it relevant conduct, if his co-defendant, Mr. Rhodes, imagine hypothetically, it was only his house, he is the only one that maintained it, and he only sold drugs out of it, and your client never did. But your client knew all about it and was a co-conspirator with him, right? Then the maintenance of a drug house would be, foreseeable to your client, right? And within the scope of the conspiracy, right? Because they got a drug conspiracy. And so I guess what I'm wondering is why it matters. Like, I think it's easy to say that Mr. Rhodes maintained a drug house. I don't think you would dispute that aspect, or at least I
do not dispute that.
And so why wouldn't we simply say under Pinkerton type analysis at sentencing that because his maintenance was foreseeable to Mr. Barnett and within the scope of the conspiracy, the drug conspiracy, that he gets the 2-point enhancement for the same reasons he gets the attribution of the drugs that were found in the house?
So what you're talking about is conspiracy theory applied to the premises enhancement. Right. And that has it's rare, but it has been looked at a few times in the case law. There is Eighth Circuit case. It's United States v. Miller, which cites United States versus Patton, I believe. And basically, the Eighth Circuit, the holding is that the Eighth Circuit assumed that Section 2D 1.1b12, which is the premises enhancement guideline, requires proof that the specific defendant being sentenced maintained the premises for the purpose of drug manufacture or distribution. The court explained that it is not sufficient that others possess the requisite purpose. And so United States v. Payton, 636 F. 3rd, 1027, 8th Circuit, 2011 is the case where that emanated from. On the other hand, there is the United States versus Holmes, an 11th Circuit case, which held that nothing in 2D 1.1b12 prohibits a sentencing court from imposing the premises enhancement based on jointly undertaking criminal activity, because unlike other sections of the guidelines where jointly undertaken criminal activity cannot be considered during sentencing, 2D 1.1b12 lacks an application note limiting its effect, or limiting the effect of Section 1B1.3 A1B, which talks about conspiracy liability. And so those are kind of the two competing cases. There are some, so basically it's a split. And there's a case out of Indiana, Northern District of Indiana. The site is United States versus Lewis, 2020 U.S. District Lexus 41691, that discusses these two cases with a similar case that judge was entertaining. And that particular judge sided with the 11th Circuit and said, I don't see anything in the guidelines that limits 2D 1.1b12 in terms of applying conspiracy theory to that particular enhancement. There's another case out of Northern District of Indiana where a different judge found the opposite and says, I can find no appellate cases out of our jurisdiction that say you can apply conspiracy theory to that enhancement, and I'm not going to do it. I'm going to stick with the plain meaning of the language in the enhancement, and he did not apply it. So those are the kind of the two competing theories as far as the conspiracy theory being applied to that particular enhancement. And I'm urging the court to obviously to take the Eighth Circuit approach and not apply conspiracy theory to the enhancement. In terms of the facts, well, in terms of the guideline itself, it simply reads that if the defendant maintained a premises for the purposes of manufacturing or distributing a controlled substance, increases total offense level by 2 levels. Application note 17 of that guideline talks about the application of the guideline. It says it applies to a defendant who knowingly maintains a premises for the purpose of manufacturing or distributing controlled substances, including storage of controlled substances for distribution. And then it says, among the factors the court should consider are A, whether the defendant held a possessory interest in the premises, i.e. owned or rented it, and B, the extent to which the defendant controlled access to or activities at the premises. And so the case law in the Fourth Circuit has developed such that the Fourth Circuit considers it a fact-specific inquiry that considers the totality of the circumstances. So for example, there's 3 cases that are similar. In United States versus Clark, 665 Federal Appendix 298, 2016. The apartment was owned by others. Clark lived out of state. She did not have a key to the apartment. However, the court still found that she controlled the premises because she had access. She stayed at the apartment at times. She had access to the interior of the apartment. And importantly, she participated in the rampant drug activity within the apartment. And thus she controlled the premises or maintained them for drug-related purposes. Likewise, in United States versus Christian, 544 Federal Appendix 188, 2013. Counsel, yes, ma'am.
So why isn't that pretty similar to what we have here? I know none of these cases are going to be exactly the same on the facts. We don't have owning or renting the premises, but if it's a very, as you said, a very fact-intense inquiry, and there was evidence that if the district court believed it, that there's a large quantity of drugs found in the house. Your client at least once, was engaged in if you believe certain testimony, engaged in a drug transaction that involved portioning out some drugs from the drugs at the house to sell to someone. And there was lots of testimony that he was constantly selling drugs, or regularly selling drugs up and down Calvary Street, and that if someone couldn't get in touch with Rhodes for their drugs from the house, they would get in touch with him. So there's drugs stored at the house with his knowledge and his use of them for controlling activities, the activity being selling drugs in and around the house. Why, if a district court believes, you said, so he's in the house on that day. Of course, he testified he was at a picnic table, but at the drug sale that was on video, but of course it was on video, and other people testified that he was at the side of the house at the door. And then there's someone who said that he was basically kind of Rhodes' second in command, which would certainly suggest that he had access to the premises to control, access to the drugs. So again, that's testimony both ways, but if the district court couldn't he find by preponderance of the evidence that there's enough here?
Well, to be fair to you, Your Honor, the guideline does say you look at the extent to which he controlled activities at the premises and not necessarily in the premises. But the case law has come down such that they looked at defendants who, although they didn't own the residence or have a key to the residence, they were inside the residence and controlling what was going on inside the residence. And so my argument is that there's very little evidence of Barnett inside the house. All of what he's doing is outside the house. And I look at it not so much as how the government characterized it, which was that he was a partner in crime with Rodney Rhodes. I look at it as more like an employer-employee relationship, as if he were Rhodes' employee doing Rhodes' bidding. It's Rhodes' house, and it was Rhodes' purpose to maintain the residence for manufacture of drug distribution, not necessarily Barnett's purpose. So if I believe if the court is going to rule against Mr. Barnett, they need to do, as Judge Richardson suggested, do so under maybe a conspiracy theory liability and say, well, we're going to take the Eighth Circuit's approach and say, he was a conspirator to Rhodes. Rhodes maintained the premises for manufacture of drug distribution. Therefore, the enhancement applies to Barnett also. But in terms of whether or not there was proof that Barnett's purpose was to maintain that residence for drug distribution or manufacture, I argue that the evidence is insufficient. And there's evidence he's there, he's engaging in drug activities, but not necessarily that he's relying on the premises for the purpose of engaging in his drug activities. So that's my response to that question.
What do you do about him running?
Stored?
I'm sorry, whose question should I answer?
Sorry, I just asked as a follow-up, you said there's no evidence he was relying on the premises. And I just asked, where were the drugs stored that he sold?
Well, that's my argument is that they were on his person. So he ran in the house and then he ran back out and then he tried to jump a fence. And then on the other side of the fence, they found some drugs in a bag. My argument is that's his drugs that are in the bag, not necessarily the drugs that are inside the house that belong to Rodney Rhodes.
What about the drugs he sold, other than on the one day, the other testimony about drug transactions?
There's no evidence on where he got those drugs. There's no evidence that he went inside the house, got the drugs, brought them back out and sold them. He may have brought them there on his person. So it's an insufficiency of evidence argument. And
why isn't the fact that he turned and ran back into the house probably the worst fact in this case for this argument, that he's just basically an independent contractor who works for somebody who runs this house, but then the police show up and his first instinct is to turn and run into the house? Why isn't that bad, and what do you say about that fact?
Because the house is at the end of a street and there's nowhere else to go. So he's trying to get away from the police. His instinct is to run into the house to get away from them. He's in there a few seconds, realizes that's a bad idea, runs back out of the house and tries to jump a fence and is unsuccessful, and he's caught. So that's my answer to that. So that's my time on opening. I'll yield to the government. Thank you.
Thank you, counsel. Counsel?
May it please the court, Anthony Enright for the United States. I'd like to begin by answering Judge Richardson's question, which is that he can appropriately be held responsible. Pinkerton-style conspiratorial liability. There you have the acts, you have a jointly undertaken activity, and it's reasonably foreseeable conduct in furtherance of that activity, because he certainly knew about the house, and it was reasonably foreseeable. Also because Barnett aided and abetted Rhodes's maintenance of the stash house. Even if this court were to assume that the evidence doesn't establish Barnett's direct maintenance of that stash house. And
do you agree with the friend? Do you agree with your friend on the other side that the Eighth Circuit has held the exact opposite of that?
I do not agree with that, because the Eighth Circuit has explicitly said that that's an assumption. And other courts have treated that as an assumption too, including the Sixth Circuit, which I think is the most recent court to weigh in on this subject, that in United States versus Rich, 14 Fed 4th, 489, that's a published opinion. It treated the Eighth Circuit's decision as an assumption that we wouldn't be creating a circuit split, and it came out consistently with what I just said, which is there's no reason 1B1.3 wouldn't apply to the stash house enhancement. There's a little bit of a debate, I suppose, because the language of the guideline itself starts with add 2 points if the defendant. That's language that the guidelines use all over the place. Sometimes they use that language, sometimes they use the passive voice. And that's a factor to consider, but the guidelines themselves make pretty clear that that language isn't designed as an exception to relevant conduct principles. For example, in 3C 1.3, which is the reckless endangerment during flight, starts the same way. If the defendant creates an unreasonable risk, but the comment says, well, it also applies if he aided and abetted somebody else who created that unreasonable
Counsel,
risk.
Could you identify to me where in your brief you argued that he could be held liable for the actions of his co-conspirator under a Pinkerton theory? Your red brief to me is all about what he did and what the evidence showed about him. I didn't see any development of this argument about these cases of the Eighth and the Sixth Circuit and whether he could be held. Where's that in your red brief?
You're 100% right, Your Honor. It's not in my brief. I was trying to answer Judge Richardson's question, but I don't claim that I asserted it in my brief. My omission, however, does not deprive this court of its authority to exercise its discretion to affirm on any ground fairly supported by the record. I do apologize for not writing it.
So I ask you, so I have another question about whether I think this, I know there are a bunch of cases of this court saying this is highly fact-bound. There are cases saying it seems like clear error review. But I guess I'm going to put, what strikes me is this case fundamentally comes down to, on the facts that I understand them, is question. Is actively participating in a drug trafficking conspiracy. But would you like to respond to that?
Certainly, Your Honor. I think there's two parts to it, and one is the point we were just talking about. If this court accepts that relevant conduct principles apply, I think the answer is in almost all cases yes. If you're participating in a conspiracy and the drug-involved premises are reasonably foreseeable, then you're going to be responsible for that. But separately from
Assume
that,
I don't agree with that. So I'd like to hear part two.
I figured that was where your question was headed. The answer, I think it's still a bit fact-specific. The word maintain, I don't know if this court needs to go as far as to say maintain includes all drug conspiracies involving a stash house. But what I think that even the plain language of the term does include is keeping a premises up, keeping its operation productivity. That's Black's Law Dictionary's language. Keeping a place's operation productivity going. It's not just maintaining it in the sense of keeping its physical integrity together or in good repair, but the operation productivity is part of it. And what this court has said in Carvajal and Holloman and a couple of the decisions that the defense has cited is storing drugs at a premises for the purposes of distribution is a kind of maintenance. And I want to maybe it'll help clear something up. The drugs that were found in the residence were the mantle, but the drugs he was charged with after the seizure. and in the house. So he was storing drugs in the house. And it wasn't just an isolated incident. This is something that went on for at months. Several witnesses testified he's dealing drugs on Calvary Street routinely, all the time. He's at that house with Rodney Rhodes all the time.
Can you respond to your colleague's suggestion that we ought to view? Maybe that's, I don't want to unfairly characterize it, but he seems to suggest that it's about what's inside the house, that the premises doesn't include the curtilage, for example, right? And so, and that comes up in some apartment cases because there is no outside. But in a location like this, where there's both an interior and an exterior that is part of that location, can you talk for just a second about whether we ought to limit the analysis to what happens inside the 4 exterior walls, or whether the premises includes, you know, the picnic table that's right outside, or however we want to describe it?
I think it includes both. And the reason is that the guideline itself, the conduct that he conducted in and around the house, at least insofar as the court can make a reasonable connection, he invited, for example, the informant. This was a transaction arranged by Barnett, according to the informant himself. He said, hey, holler at me. Come back. I got some good drop. And he invited him back to that he went back to that location at the premises. And I think defense is correct. I think the transaction occurred outside, immediately adjacent to the premises. But that is an example of the defendant controlling access to or activities at the premises, which is what the commentary asks the court to focus on. And again, not isolated. He's conducting this drug business on Calvary Street, which the premises were at the end of. This was, in the words of the district court, their headquarters. They're using it as their headquarters. The district court inferred from all of this evidence that they were storing drugs there on a regular basis and coming out and dealing drugs on the street. It wasn't just that they happened to come into the same area, but they were using that house as their headquarters. And that is not a
Counsel, can I ask you, how much does your argument in this case depend on the fact that Barnett and Rhodes are cousins? Because I'm trying to hypothesize these exact same set of facts where the individuals are not related to each other at all. And I have an intuition that it might make a difference. I'd like you to articulate that, right? Because it seems very clear this was Rhodes's house. I mean, there's paper with his name on it, right? And you obviously mentioned several times in the brief can you just talk about how much, whether and to what extent it matters that these individuals are related to each other?
I don't believe it matters in isolation. That's perhaps one of the ways we know that they were working together. But we also have eyewitness testimony that these two were working closely together. That, for example,
yeah, but assume to go back to something your colleague was saying. I don't think there's really much doubt that they were working together. But there's, the district court. I agree. The district court said it was their headquarters, which implies to me that there's something akin to partners. But another way to describe it is they're an employer and an employee, and maybe the answer is different, right? I think you could make sense to say that if there are two partners working out of the same place, they're both maintaining that place. If there's a master and a servant, though, I'm not sure we would say the servant is maintaining the place that the person works. So could you talk a little bit about that?
Yeah, I suppose I disagree with that premise. I do not think that this guideline is designed to draw a hierarchy. There's another specific offense characteristic and guidelines for that, which is a managerial role versus a minor role. But in this case, and to give a couple examples, Clark was one I can think of, and there's a couple other examples where this enhancement was applied to someone who was undisputedly a subordinate in a larger operation. Clark was, I think, the subordinate of a fellow named Freeman. And I do think you can analogize it to an employer-employee relationship. I'm a little reluctant to sort of embrace the formality here because it is a totality of the circumstances kind of thing, but certainly you could say that, for example, the manager of a pizza company, a pizzeria, is maintaining the pizzeria even if he's not the one with the ownership in the pizzeria or there's a higher boss.
So I totally get that. Let me give you another example then that maybe helps illustrate what I'm a little concerned about. I want you to imagine that there were
one not getting it.
No. I think this is genuinely hard. I mean, so now imagine that instead of Barnett, imagine there are 10 other people selling drugs out of this house. It's Rhodes's house, and there are 11 people who sell drugs out of this house, and they do all the things that Mr. Barnett did. Is the government's view that every one of those 11 people is maintaining the house?
I think that's a possibility, Your Honor, if you're talking about a situation where every one of them is storing drugs in that house and on a regular basis calling people to come to that house to conduct their drug business.
Well, then it just strikes me that the government is interpreting maintaining as work out of. That maintaining is just a synonym for working out of. Because I don't think it's plausible. Unless maintaining means working out of, it strikes me as hard to say that those 11 individuals are all maintaining the house.
I think the key difference working out of would be significantly harder than this case, because what Mr. Barnett did was store his drug distribution materials, his scales, his bags in the house. And in addition to that, conducted his drug transactions in and around the house, and did so for a sustained period of time. That strikes me as a much harder case to say, well, any kind of working out of the house. If they bring their own drugs in their pocket, but maybe they go into the house to use the restroom or get some water or something, but they're working the streets, harder case for us, I think. If you did have some kind of big house where each person's got their own setup selling drugs in a room, I think that's a much fairer case to make, because every one of those people is responsible for converting this piece of property into a drug-involved premises. This is something Congress was particularly concerned with. This guideline was a response to a particular congressional directive in the Fair Sentencing Act of 2010. And Congress said, we want to make sure that you get an enhancement for maintaining the kind of premises described in 21 U.S.C. 856, which is a drug-involved premise. And that's a long-standing statute that was focused on the damage to property and the damage to the neighborhood by making a house into a drug premises. And if everyone were doing that, I think they would all be equally responsible. At least as responsible as the person who perhaps wasn't doing that but had a key to the place and just let them do it. So I suppose that's my answer. I don't think the court needs to go as far as saying any drug house someone's working out of, but I think this case makes it a little bit easier. It is one he ran into in response to the police. It is one he was working out of regularly. He was a very close associate and someone who was working with the person who it's conceded was maintaining the house. And he stored his drugs and drug supplies there. So I think this court can affirm the decision of the district court, and ought to, both because of Mr. Barnett's conduct directly and through the principles of relevant conduct. And if this panel has no further questions, I will yield the balance of my time back to the court.
You got some time on reply, counsel?
Thank you. I want to start by saying that the guideline and the application notes say manufacture or distribution or storage for subsequent distribution. There's no evidence that Keith Barnett sold or distributed drugs that had previously been inside that house. There's no evidence that he manufactured drugs inside that house. There is some evidence, and that was this district attorney's testimony from state who had prosecuted Mr. Barnett in state court. He came into the federal case and said, hey, I was there the day he made his first appearance in state court, and he told the judge he takes responsibility for the drugs. They're not Mr. Rhodes's drugs. However, it's unclear what drugs he's talking about. And the defense counsel asked him, he said, how do you remember this? And the district attorney said, I remember it because he was charged with trafficking in cocaine. But Keith Barnett was not charged with trafficking in cocaine. The record lists what he was charged with that day. It's in volume 2 of the supplemental joint appendix, page 466. There's paragraph 67 there, lists the 8 charges that he had that day from state court, none of them are trafficking in cocaine. There are 3 trafficking in heroin charges. To get trafficking in heroin in North Carolina, you got to have at least 4 grams of heroin. To get trafficking in cocaine in North Carolina, you got to have 28 grams of cocaine. The drugs that were found in that yard were 0.5 gram of cocaine and 8 grams of heroin. So was Keith Barnett talking about the drugs found in the yard, or was he talking about the drugs found in the house when he says, I take responsibility for the drugs, they're not Rodney Rhodes's drugs? It's unclear from the district attorney's testimony as he's saying this. So
do we get to do that? I mean, the district court found that it applied, and it seems like to me in that context, I mean, you know, all right, even if you have a way to question the credibility of some evidence, we typically take the evidence in the light most favorable to the district court's ruling in this context, right? We don't go back.
Yeah, it's a deferential standard, and it has to be clear error. But again, my argument's an insufficient evidence argument. There's not a lot of evidence that puts Keith Barnett's activities inside that house. And so the guideline says manufacture, distribute, or store for distribution. For all we know, Keith Barnett brought his own drugs to the house. Rodney Rhodes let him sell drugs outside the house. And that was Keith Barnett's role with respect to that. And so if you're going to say, well, the premises enhancement applies to Barnett, you're going to have to base it on the language in the application note that says at the premises and not necessarily inside the premises, because the evidence was that Barnett was this employee type guy who was allowed to sell drugs outside the house, not that he was an integral part of what went on inside the house. And that's the bottom line. So I ask you to rule in favor of Mr. Barnett and strike the enhancement and return it to the district court for resentencing. Thank you.
Well, we certainly appreciate your argument and note that you're court appointed, and certainly appreciate you continuing to take that and doing your characteristically excellent job of representing your client. We would love to come down and greet you as always. Unfortunately, we can't do that, but we look forward to doing it in the future. And thank you for your service. With that, we'll ask court to close in court for the day.
Thank you, Your Honor.
Thank you, Your Honors.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.